we've prepared a short video summary of 4 cases that dealt one way or another with schools. Let's look at that summary, and then Erwin Chemerinsky and Susanna Sherry will have some comments.
Gonzaga University v. Doe involved FERPA, the Family Educational Rights and Privacy Act of 1974. It directs the Secretary of Education to withhold funds from schools that release students' educational records or information in them without written consent. Gonzaga gave state teacher certifying officials information, untrue as it turned out, that Doe had raped a fellow student. Doe sued in state court. One of his claims was a Section 1983 claim that Gonzaga violated his FERPA privacy rights when it divulged the rape accusation. Does FERPA create such a right enforceable in court? No, said the Supreme Court 7-2. Chief Justice Rehnquist, acknowledging some ambiguity in earlier cases, said we now reject the notion that our cases permit anything short of an unambiguously conferred right to support a cause of action brought under Section 1983. A court's role in discerning whether personal rights exist in the Section 1983 context should not differ from its role in discerning whether personal rights exist in the implied right of action context. Both inquiries simply require a determination as to whether or not Congress intended to confer individual rights upon a class of beneficiaries. FERPA revealed no such intention, he said. Its provisions speak about institutional policy and practice, not individual instances of disclosure. They expressly authorize the Secretary of Education to deal with violations of the Act. Earlier in the term, well before the decision in Gonzaga, the court heard a separate FERPA case. Christa Falvo claimed that when Owasso, Oklahoma teachers permitted classmates to grade her children's papers, the school was divulging school records. Contrary to its later decision in Gonzaga, the court assumed without deciding that FERPA created a private right of action, but then unanimously rejected Falvo's claim. The papers that students grade, at least at the time they grade them, are not records maintained by the school. The student graders are not acting for the school in an agent-principal relationship. Moreover, the majority said, to decide against the school district would affect a drastic alteration of the existing allocation of responsibilities between states and the national government in the operation of the nation's schools. Given the decision in Gonzaga, the main importance of this case may be to caution educational agencies against threatening loss of funds under FERPA for peer grading. Another case involved drug testing. In 1995, in Vernonia School District v. Acton, the court upheld random suspicionless urine tests of student athletes. The question this term, may schools authorize similar tests of students involved in competitive non-athletic extracurricular activities, such as choir or academic teams? Yes, said the court 5-4, in a case brought by Lindsay Earls against the Pottawatomie County, Oklahoma School District. The court conducted what Justice Thomas called a fact-specific balancing of schools' special custodial obligations to students and the students' Fourth Amendment privacy rights. Here, with regular comparisons to the drug testing policy in Vernonia, the court first concluded that even non-athletic extracurricular activities impose some intrusions on participant privacy and thus create a lesser privacy expectation. Second, the urinalysis procedure reasonably protected student privacy and confidentiality. Third, Justice Thomas recognized what he called the nationwide epidemic of drug use. He accepted the district court's findings that Pottawatomie schools faced a drug problem and said that the school board didn't have to wait until it faced a crisis to act. Finally, in Zellman v. Simmons-Harris, the court, by a different 5-4 majority, sustained an Ohio statute that gave tuition vouchers to families of schoolchildren in Cleveland. The Ohio program authorized checks of between $2,000 and $4,000 per student for families well below the poverty line. The families, in turn, would endorse the checks over to participating religious or non-religious schools as partial tuition payment. Suburban public schools could also participate, but none did. Partly for that reason, and because most private schools in Cleveland are religious, 96% of the students who used vouchers attended religious schools. The Chief Justice said that the program was enacted for the valid secular purpose of providing educational assistance to poor children in a demonstrably failing public school system. Thus, he looked to the program's effects. Citing earlier cases, he said the Cleveland program did not violate the Establishment Clause. Why? Because the funds went directly to parents, and they decided whether to use the vouchers at religious or non-religious schools. Any advancement of religion or perceived endorsement of a religious message is a result of individual choices, not the program itself. The Chief Justice acknowledged that the great majority of voucher aid went to parochial schools, but he said that's because there are more parochial schools than other kinds of private schools in Cleveland. Moreover, in addition to the voucher program, the statute authorized funds for tutorial aid for public school students and for magnet and community schools. Accounting for all program spending considerably reduced the proportion of total program funds that went to religious schools.
Here to comment on these cases are Erwin Chemerinsky and Susanna Sherry. And Erwin, let's go to the Gonzaga case. This is the one that involved private right of action under the FERPA, which is a schools case, but it's really more important for what it says about federal court jurisdiction, isn't it?
I think that's right. The Federal Educational Records Privacy Act was adopted by Congress under its Spending Clause authority. The Supreme Court, in an opinion by Chief Justice Rehnquist, said that Section 1983 could not be used to enforce the statute. I think the greatest significance of the case is the Supreme Court says that 1983 cannot be used to enforce a law adopted under the Spending Clause unless that law would have under it a private right of action.
I think that this case is quite significant for both those reasons. First, as Erwin noted, the case limits the enforcement under 1983 of these various spending clause statutes, and that could have a fair amount of significance for the enforcement of Social Security statutes such as Medicare and Medicaid. And also, this is the first time that the court has said that determining whether a cause of action exists under 1983 is the same as determining whether there's a private cause of action directly under the statute. That's new, and it's a much more restrictive test than they had been using under 1983 before.
Okay, thanks. Let me ask you, in light of getting back to what it did to FERPA, though, how significant is this case from Oklahoma that we saw about, which said that peer grading does not violate the FERPA statute?
Well, I think it's interesting because it continues a trend that the court has been doing lately. The court used its new federalism principles to interpret FERPA rather than to strike it down, to say that they were not going to interpret FERPA to work a drastic reallocation of authority between Congress and the states and the local governments unless they got a much clearer signal from Congress.
I think that's right. This is one of a number of instances in the last few years where the Supreme Court has interpreted statutes to avoid constitutional doubts using federalism principles to narrowly construe statutes. We saw it earlier in the Raygor case where the court used the 11th Amendment to narrowly construe the supplemental jurisdiction statute. A couple years ago, the court did this for the Key Tam statute in the Vermont Agency of Natural Resource cases. And also, in the last few years, there were a couple of Commerce Clause cases. The Solid Waste Agency case, United States versus Jones, where the Supreme Court said we're going to interpret statutes narrowly to avoid possible problems under the Commerce Clause.
So there's a strong federalism component here. Right. Thanks. Susanna, the other case from Oklahoma, obviously, that we saw dealt with random drug testing of students in extracurricular activities. And the question is, how far can school districts take this ruling in terms of testing students for drugs?
Well, the majority opinion is quite broad. Justice Thomas made clear that you don't have to have an immediate drug crisis before you take remedial steps. You don't have to have a demonstrated drug problem, although it helps to have some justification. And certainly you don't have to have any problem at all among the particular targeted population, in this case, students participating in extracurricular activities.
Mm-hmm. I think Justice Thomas' opinion would seem to allow a school to test any student anytime it wanted. He emphasized that schools have an interest in stopping and preventing drug use. He says drug testing is a minimal intrusion onto privacy.
I think Justice Thomas and several of the other justices would go that far, but I don't think that Justice Breyer would. Now, Justice Breyer's concurrence was necessary to the 5-justice majority, and he emphasized the fact that, first of all, not all students were tested, and in some sense more important, that students had a right to opt out, but they could just decide not to participate in extracurricular activities. So I think that Justice Breyer would not allow drug testing of the whole student population without a much stronger justification.
The courts ought to watch for that. Thanks, Susanna. Erwin, of course, I guess the biggest case this term for schools and a lot of other things was Zellman. Immediately after the decision, people were saying this is the most important case since Brown versus Board of Education as regards schools. Do you think it is? Consider that question in terms of federal courts. I'm asking a lot of federal litigation after Brown. What's going to happen after this case?
I don't think that this case is going to produce a good deal of litigation in federal courts. But I think what this case really does is take the voucher issue out of the courts and transfer it to the political process. There'll still be some legal challenges to some voucher programs. There's still an issue of how broad do the range of options have to be for parents for a voucher program to be constitutional. This particular law had a clause that said that schools receiving vouchers couldn't discriminate based on race or religion. Well, what if a law didn't have that kind of a clause? Would that be constitutional? And for laws like this, that have these kind of clauses, some schools might challenge it if they want to discriminate based on race or religion and say that it's unconstitutional to keep them from doing so.
I think that as to race discrimination, earlier cases show that you can probably refuse federal or state subsidies for schools that discriminate on the basis of race. But I think you're right, it's an open question whether a voucher program could constitutionally exclude schools that wanted to select their students on the basis of religion.
So follow-up litigation isn't over.
That's right.
Thanks, Susanna. Thanks very much, Erwin. Next, a case involving intellectual property. One of the term's most closely watched commercial cases involved the relationship of two patent law concepts, the doctrine of equivalence and the rule of prosecution history estoppel. We prepared a brief summary of that case, a dispute between the Festo Corporation and the United States branch of SMC of Japan.
The doctrine of equivalence stems from Winan v. Denmead, an 1854 Supreme Court case. The words of a patent application, said Justice Curtis, rarely can describe all forms that the invention might take. The patentee, having described his invention and shown its principles and claimed it in that form which most perfectly embodies it, is deemed to claim every form in which his invention may be copied. The inventor is protected against infringement of the precise device described in the patent and against infringement by equivalent devices that differ in only insubstantial ways. There is, however, a tension between the doctrine of equivalence and the notice function of claims. The patentee, through the claims, gives notice to the public of what is covered by the patent. If the applicant, during the give and take of prosecuting the patent application, disclaims a particular form or aspect of the invention, she cannot later invoke the doctrine of equivalence if someone produces the device in the form that was disclaimed. This prosecution history estoppel is a direct limit on the scope of available equivalency. The court has said that the public may rely on prosecution history to identify where the applicant may have narrowed her claim, and that any estoppel that may arise should be determined on an element-by-element basis. Festo involved two features of a magnetic rodless cylinder. Fluids move the piston, and the piston moves a magnet outside the cylinder. The Festo cylinder uses two one-way sealing rings. SMC's a single two-way ring. The sleeve on Festo's cylinder is made of a magnetizable alloy. SMC's of a non-magnetizable alloy. SMC's device thus fell outside the literal words of Festo's claims, but Festo argued that it was so similar as to be an equivalent. SMC responded that the rings in the sleeve were added to the Festo application during the prosecution history. Festo was thus estopped from saying that SMC's device was an equivalent. Festo argued that no estoppel arose because these elements were not added in response to any prior art cited by the patent examiner. En banc, the Court of Appeals for the Federal Circuit held first that estoppel arises from any amendment that narrows the claims in order to satisfy any requirement of the Patent Act. On this point, the Supreme Court agreed. Justice Kennedy said in his unanimous opinion that estoppel arises when an amendment to the patent application narrows the patent scope. Such narrowing can result from prior art objections, but also from objections based on other statutory requirements. In a second, more controversial aspect of the decision, the Court of Appeals 8-4 held that when estoppel does arise, there is a complete bar against any assertion of equivalence for the amended element. A complete bar, said the majority, would end confusion and extensive litigation. The dissenters said it was an inadequately considered venture into industrial policy that would devalue most patents. Justice Kennedy said the Supreme Court's precedents favored a flexible rather than complete bar. An amended application is a concession that the patent does not extend as far as the original claim, but it does not follow that the amended claim becomes so perfect in its description that no one could devise an equivalent. The burden, though, is on the patent holder to show that the amendment did not surrender the particular equivalent in question. How? By showing that the equivalent device was unforeseeable at the time of the application, or the rationale underlying the amendment bears only a tangential relationship to the equivalent in question, or some other reason suggesting that the patentee could not reasonably be expected to have described the insubstantial substitute.
Forthcoming cases in the Federal Circuit may suggest how much this decision narrowed the doctrine of equivalence. Shortly after deciding Festo, the Supreme Court granted 9 certiorari petitions. It vacated the judgments and remanded for review in light of Festo. In each case, the Federal Circuit had applied its now rejected absolute bar. We'll take another short break and then turn to the criminal law and procedure and habeas cases. The second part of our review of the 2001 October term deals with criminal law and procedure, sentencing, and habeas corpus. First, Lori Levinson is going to take us through some of the criminal law and procedure decisions. And we'll start with search and seizure, but before we get to the specific decisions, Lori, what kind of a term was this for the Fourth Amendment? Two cases we'll discuss in a moment, then of course the school case, Earls, which was not a criminal case.
And it wasn't a criminal case because the court made a point of saying that the drug test results did not go to law enforcement. But as to the search and seizure cases this term, I would say that they were meat and potato. They were the type of issues that district court judges deal with all the time.
And one of those is what justifies a Terry stop.
That's right.
Which was at issue in U.S. versus Arvizu, which involved a border agent stopping a van in southern Arizona near the border. And he cited a variety of factors. The van seemed to avoid checkpoints. The kids behaved in a strange way. But the Court of Appeals said none of these factors gave rise to reasonable suspicion. The court, in a decision that was unanimous and quickly rendered, said, oh, that was fine.
That's right, because what the court said is that the standard for reasonable suspicion is totality of the circumstances. And in this case, where you had a man and a woman and some uncomfortable kids in the back seat, the driver didn't want to wave at the border officer, they were on a road that could be used for smuggling, that the court could defer to the expertise and training of the customs officer to say whether that was appropriate for reasonable suspicion. This gives a great deal of deference, but it also opens up the door to possible racial profiling.
What about the bus case we had this term, U.S. versus Drayton? This involved a regularly scheduled stop of an interstate bus in Tallahassee, and Tallahassee police officers, pursuant to a regular drug interdiction program, boarded the bus with an officer in the back of the bus, an officer in the front of the bus, in the driver's seat looking back, and then the third officer, out of uniform, walked up the aisle and just asked each passenger, told him what he was doing, and asked if they could look in the luggage and also search the person. Which led to a discovery of drugs in the case of Drayton and the arrest. Now, the officers didn't tell Drayton or any of the other passengers that if they didn't want to cooperate, they didn't have to, but the court said they weren't obliged to tell them that.
That's right. The court was clarifying something from Florida versus Bostwick. What they clarified is that you do not have to advise somebody ahead of time that they have a right to refuse consent. That the standard for voluntary consent is once again that totality of the circumstances. And in this case, because the officer, even though he was right in the face of the passenger, he was soft-spoken, he did not display a weapon, he didn't block the way, the court said that's okay, that is voluntary consent. Now, the dissent says, well, it's a little bit like being confronted in a narrow alleyway, but the majority said, look, most people, they're willing to consent because they're concerned on transportation with their own security.
As in airports, for example.
Right, but this was a bus.
I understand. Brady material and plea bargains. This is the case of U.S. versus Ruiz, again 9-0, involving the fast-track plea bargain approach that some district courts have adopted. The defendant waives the right to trial and appeal, also waives the right to impeachment information about informants and witnesses, and in return the government promises to make a reduced sentencing recommendation. Court of Appeals thought this was unconstitutional. The Supreme Court, as I said again, 9-0, said no, this is fine.
Yeah, they said basically you can waive these rights and you don't have a due process Brady right for guilty pleas. In this situation, what the defendant didn't get was impeachment information regarding the informant. It wasn't the exculpatory information. And the court felt comfortable that Rule 11 procedures were enough. You don't have the right to perfect information.
Finally, McCune v. Lyle, Lori. We talked earlier of Kansas' Sexually Violent Predator Act, which involves civil commitment after the criminal sentences of sexual offenders. Kansas has another program, the Sexual Abuse Treatment Program. This provides counseling to sex offenders before their release. The effort is to avoid recidivism, obviously. And a key element of the program is that the participants have to admit to the crimes, the sex crimes of which they're charged. Now, McCune refused to do that. He was convicted of rape. He said it was consensual. He testified under oath to that effect. And he said, consequently, I'm not going to admit to a crime I didn't commit. I'm not going to participate in the program. To which the prison authorities responded, well, you're going to lose some privileges, some visitation rights. You're going to move into a high-security area of the prison. And the question is, the court upheld this, how far can prison authorities take this decision?
Pretty far. I mean, what this decision holds is that the defendants have a lesser Fifth Amendment right in prison settings, whether it be clemency hearings, disciplinary hearings, probation revocations. As long as the prison has a legitimate penological interest in their program, they can impact on somebody's Fifth Amendment rights. So overall, under this program, which is not voluntary, they have to participate in it. It doesn't matter. They have to admit these crimes, and if they don't, they can suffer these punishments. And the court says it's not like torture, the punishments. It's more de minimis, and therefore we say it's okay. Now, the concurrence says this is a new type of Fifth Amendment jurisprudence, which isn't based upon coercive effect. It's based upon loss of liberty interest. But nonetheless, the court says we're going to defer to the prison authorities. And the dissent says, look, if what you're really interested in is rehabilitation, give these guys immunity and get them in the program.
What would this have done, just out of curiosity, to the sentencing guidelines had it gone the other way?
Well, under the sentencing guidelines, there's an acceptance of responsibility provision, but you have to accept responsibility and admit your crime. The question is, if they had gone the other ways, would that be impacted? Well, since they didn't, that's not impacted. That's still a valid provision.
Okay, thanks, Laurie. Finally, it's worth noting that the court, under the Rules Enabling Act, refused to forward to Congress a Judicial Conference proposal to change Criminal Rule 26. New Rule 26B would have permitted testimony at trial by two-way video under exceptional circumstances with safeguards in place and the witness unavailable. Justice Scalia filed a statement explaining that he believed the proposal violated the Confrontation Clause standards set out in Maryland v. Craig. Justice Breyer filed a dissenting statement, which Justice O'Connor joined. Now, the court did forward the conference's proposed amendments to Criminal Rules 5, 10, and 43, allowing videos used for initial appearance and arraignment if the defendant consents. We'll be right back to review this term's sentencing decisions. Few recent cases have generated more litigation than the decision 2 terms ago in Apprendi versus New Jersey. We prepared a brief video segment about Apprendi and how the court interpreted it in 3 cases this term. Let's look at that segment, then Evan Lee and Laurie Levinson will have some comments on those cases and the Atkins case on the death penalty and the mentally retarded.
In 1994, Charles Apprendi fired several bullets into the home of an African-American family that had recently moved into a previously all-white neighborhood outside Vineland, New Jersey. He pled guilty to 3 state felony gun and bomb possession counts, which each had a maximum of 10 years. The standard of proof was guilt beyond a reasonable doubt. In addition, New Jersey's hate crime law provided for an extended sentence if the judge found, by a preponderance of the evidence, that the gun violations had been motivated by racial bias. At sentencing, the judge found bias, imposed a 12-year prison sentence, and sentenced Apprendi to shorter concurrent sentences on the other counts. On appeal, Apprendi argued that the 12-year extended sentence, 2 years longer than the penalty for the crime of conviction, violated the Constitution. The Supreme Court agreed in a 5-4 decision. The court held that, other than the fact of a prior conviction, any fact that increases the penalty for a crime beyond the prescribed statutory maximum must be proved beyond a reasonable doubt. Prosecutors and defense counsel have pressed lower courts with their views of Apprendi's implications. This term, 3 such cases reached the Supreme Court. First, U.S. v. Cotton. In 1998, a Baltimore jury convicted Leonard Cotton and 12 others on a federal indictment involving distribution of a detectable amount of drugs. For Cotton and 6 others, the quantities at issue were sufficient to trigger an enhanced penalty. But the indictment, like most pre-Apprendi indictments, did not specify drug quantities. The maximum penalty for unspecified amounts of drugs is 20 years, but the judge sentenced Cotton and the 6 others to terms ranging from 30 years to life. Uncontested evidence at trial put their drug amounts at the levels of the enhanced statutory penalties. While an appeal was pending, the Supreme Court decided Apprendi. Cotton and the 6 others argued that their sentences, given the nonspecific indictment, were invalid. The Court of Appeals vacated the sentence. Citing the 1887 case of Ex parte Bain, it said the district court lacked jurisdiction to sentence defendants to the enhanced penalties because those penalties attached to crimes not charged in the indictment. The Supreme Court reversed unanimously. First, the court overruled Bain insofar as it held that a defective indictment deprives a court of jurisdiction. The court then applied 52B's plain error test and upheld the district court's sentences. Here there was plain error. The indictment did not allege a fact, drug quantity, that increased the maximum sentence. But after making plain error determinations, courts ask if the error seriously affected the fairness, integrity, or public reputation of judicial proceedings. No, said the Chief Justice, the evidence of drug quantities justifying the enhanced sentences was overwhelming and essentially uncontroverted. Harris v. United States was more controversial. In 1999, William Harris, an Albemarle, North Carolina pawn shop owner, was arrested when he sold marijuana several times to an undercover federal agent. All the while, he was wearing a gun at his hip. Once he showed the agent the gun and its bullets, noting that they could pierce armored jackets. 18 U.S.C. Section 924C1A makes it a crime to carry a firearm during a drug trafficking crime. Subsection 1 authorizes a sentence of 5 years to life, but subsection 2 increases the minimum to 7 years for brandishing the gun. The government assumed that 924C1A created a single crime and that the brandishing was the sentencing factor. The indictment thus said nothing about brandishing. The judge imposed a mandatory minimum of 7 years based on the gun brandishing. On appeal, Harris argued that Apprendi demanded that the government prove beyond a reasonable doubt violations that increase a mandatory minimum. He said an enhancement beyond the statutory maximum curtails an offender's liberty, but so does a mandatory minimum. The Fourth Circuit, however, and the Supreme Court, 5-4, held that enhancements within the statutory maximum do not violate Apprendi. Justice Kennedy said, "Not all facts affecting the defendant's punishments are elements which must be proven to a jury." Based on several analyses, he said that Congress intended gun brandishing to be a sentencing factor rather than a separate crime. In dissent, Justice Thomas would have extended Apprendi to this case, and in doing so possibly cast doubt on the constitutionality of the federal sentencing guidelines. This term's third Apprendi case, Ring v. Arizona, involved judge versus jury imposition of the death penalty. In Arizona, the judge, not the jury, determines whether to impose the death sentence. The Supreme Court upheld the Arizona system in the 1990 case of Walton v. Arizona. The Apprendi majority said that their decision would not disturb the Arizona system, given the special nature of capital sentencing determinations. The Apprendi dissenters disagreed and were proved correct this term in Ring. A jury convicted Timothy Ring of felony murder during an armed robbery. To execute Ring, Arizona required the judge, not the jury, to find certain aggravating circumstances. The judge did and sentenced Ring to death. That, said Justice Ginsburg, violated Ring's Sixth Amendment right to trial by jury. Apprendi, she said, means that if a state makes an increase in a defendant's authorized punishment contingent on the finding of a fact, that fact must be found by a jury beyond a reasonable doubt. This is true no matter how the state labels the fact. It made no difference that the jury's first-degree murder conviction carried a maximum sentence of death. To actually impose the sentence, the judge must make additional findings. 4 state sentencing laws are like Arizona's. In 4 other states, judges make the final sentencing determination after consulting juries' advisory opinions.
Your materials at page 17 contain information on cases leading up to Apprendi and a chart showing the justices' voting patterns in those cases and the 3 this term. You may find them helpful in understanding the evolution of the case law. Evan Lee is now here to help us review this term's sentencing cases. And Evan, we should start with Cotton. This was the case involving the indictment that didn't specify the drug amounts, which tells us about cases that were on appeal when Apprendi came down. Anything startling here?
No, I don't think so. What it tells us is that at least with respect to this one type of Apprendi error, that being the failure to allege critical facts in an indictment, we now know some things. In the absence of very unusual circumstances, the plain error test will apply. If there's no objection at trial, if there's sufficient evidence of guilt, well, then neither justice nor the integrity of the proceedings is compromised, and they're not going to reopen.
Okay, and that case was 9-0. Thanks, Evan. Now, Lori, the Harris case, this is the case that said 5-4 that gun brandishment, which raised the mandatory minimum, did not violate the Apprendi decision, was not inconsistent with Apprendi. Does this mean that mandatory minimums are out of Apprendi's reach?
Well, by and large, what the court did hold is that mandatory minimums at this point are not affected by Apprendi, and they didn't take it to what Justice Thomas would say would be the logical extension of Apprendi, saying anything that impacts on sentencing should be pled and proved to the jury. Instead, the court said, look at it this way. The jury has to make the findings that give us the maximum sentence. But within that maximum, we can have guidelines to direct the trial judge's discretion by sending mandatory minimums, and Apprendi doesn't affect that. The court did leave open the possibility, however, that if the legislatures start passing these sentences of very long maximums for relatively minor crimes with mandatory minimums, that maybe that would raise an Apprendi issue.
And that may come up, we'll see.
That's right.
Thanks. Evan, I think the big case, the big Apprendi case, obviously is Ring versus Arizona. Now, Arizona and several other states, as we saw in the video, have the Arizona system, and then several other states have systems where the juries make advisory opinions and the judge finds the aggregating factors. In those states, but in states generally, what do you think trial courts, federal trial courts, are going to be faced with Ring as a precedent?
I think they're going to be facing a lot of issues. One, obviously, is retroactivity. What about prisoners whose appeals have already been, direct appeals have already been exhausted by the time Ring comes down? Will they be able to benefit from this rule? Their argument is going to be, well, it constitutes a watershed rule of criminal procedure within the meaning of Teague versus Lane. One possible problem there is, well, Apprendi itself has not been declared a watershed rule, and in fact a number of courts have held the other way. Another question I think they're going to be facing is, what about those states that require an absence of mitigating circumstances in order to make a defendant eligible for death? Does that absence of mitigating circumstances now have to be proven to a jury beyond a reasonable doubt? Still another question, what about unadjudicated prior misconduct that in many states that goes to the question of future dangerousness or continuing threat. What about that? Will that have to be proven beyond a reasonable doubt to a jury?
And yet another issue that I think is pending is the question of how this impacts the federal death penalty law. Do aggravating factors have to be presented to the grand jury, pled and proved to the jury?
In fact, is the federal death penalty statute, as it regards the jury indictment, grand jury indictment, is it safe?
That's right, and in a high-profile case, we've got a challenge right now.
Let's turn to the Adkins decision. There's a lot of talk that Ring and Adkins may indicate a basic change in how the court views capital punishment. Let's put that aside and just tell us, what did the court decide in Adkins versus Virginia?
What the court decided is that it's a violation of the Eighth Amendment cruel and unusual punishment clause to impose the death penalty on mentally retarded defendants. And the court certainly thinks that it's dealing with a very narrow group of defendants, those who have an IQ under 70, who can show from their prior medical history, going back to their younger years, under the age of 12, that they have this type of condition. Doesn't think that it's overall getting rid of the death penalty. I think what this spills for the district court judges is that they're going to have a battle of experts, trying to figure out who's mentally retarded, who's not.
Yeah, and another question is the Ring overlay. I mean, is the absence of mental retardation now going to have to be proven to a jury beyond a reasonable doubt?
Okay, thanks, Evan.
Sure.
And thank you, Lori. Next, we'll discuss habeas corpus. Finally, 5 cases on the law of habeas corpus. Erwin Chemerinsky and Lori Levinson will explain and analyze them. And we start, Lori, with 2 capital cases. Start with Mickens v. Taylor. This was a 5-4 case, and the facts are a little complicated by the original trial, so let me just go through them, and we'll put them up on the screen so the viewers can see what these dates are. In 1992, Friday, March 20th, Brian Saunders was appointed to represent a person named Timothy Hall on assault charges, and the next week, Saunders met in his office with Hall, briefly. Monday, March 30, Hall's body was discovered with 149 stab wounds to all parts of the body, and there was evidence of forcible sodomy. Friday, April 3rd, a state judge dismissed the charges against Hall, now deceased, and entered the dismissal on a docket sheet that showed Saunders as Hall's lawyer. The next day, Saturday, April 4th, Mickens was arrested for premeditated murder of Hall during a forcible sodomy attempt. And then on Monday, the next Monday, April 6th, the same judge who had dismissed the charges against Hall appointed Brian Saunders, who had been Hall's attorney, to represent Mickens against the charge that he had murdered and forcibly sodomized Hall. Saunders represented Mickens at trial and during the sentencing hearing, but he had separate counsel on habeas, and it was the habeas counsel who stumbled upon these facts. Now, let me ask you, what was the specific question here as framed by the majority, and how did Justice Scalia answer it?
Well, the question was, is this ineffective assistance of counsel to have a conflict of interest for the lawyer between his representation of a prior client and now his representation of a death penalty defendant? And the court said, look, it's not the type of conflict where in Holloway we're going to presume prejudice. You have to meet the Strickland standard, and you have to show prejudice, and you haven't done that in this case. The dissent has said, well, how will we know whether there's prejudice, because we didn't have a lawyer without a conflict to make that showing. But nonetheless, the majority said this lawyer, because he wasn't aware of his duty of confidentiality, his ethical duty to the prior client, he didn't have any prejudice.
I think the court is saying that not every breach of an ethical duty by a defense counsel is ineffective assistance of counsel. Lawyer, I think you're completely right that in the concurrent representation situation, courts still have a duty to make inquiry under Holloway. But for other conflicts of interest, the court is saying it's going to only be ineffective assistance of counsel if the defendant can show prejudice, that representation was actually adversely affected.
Okay, thanks, Erwin. Let's stay with you and ask about another capital case, this one from the Sixth Circuit. This is Bell versus Cohn. And here Gary Cohn claimed that his counsel at the sentencing hearing just didn't even put on a case. He didn't present any mitigating evidence. He didn't make a summary argument because he didn't want the prosecutor to have a chance for rebuttal. And he said on habeas, after the state courts upheld his conviction and sentence, that the standard by which to judge and determine whether or not this decision was contrary to Supreme Court precedent is the chronic case, which means when there's no representation, you don't even have to show prejudice. The court said no, 8-1, I might point out. The court said no, 8-1, that Strickland was the right test, and furthermore, the attorney passed the test.
What's key here is it was a habeas case. The court went back to 2254 D1 and said that the defendant can get relief if the state court decision was either contrary to or an unreasonable application of clearly established federal law. And the Supreme Court said that either of those clauses is sufficient under Williams versus Taylor. Here, as you said, the state court applied Strickland versus Washington. The Sixth Circuit reversed, saying that chronic was the appropriate standard. And the Supreme Court said that when the State Court of Appeals applied the Strickland test, it wasn't contrary to or an unreasonable application of clearly established federal law. Indeed, the Supreme Court affirmed that Strickland versus Washington is the test here, and the Supreme Court said it was met.
Because Strickland has a very deferential standard as far as trial counsel. Well, let me ask you not about a capital conviction, but about a conviction for a third-degree assault. This is Alabama versus Shelton. And the trial judge in this case did not appoint counsel for Shelton. He represented himself. And then he said on habeas that he was denied counsel. His sentence was probation and a fine. But he said he deserved counsel nonetheless. And the court 5-4 agreed with him.
The key here is the Supreme Court said he was on probation. It was a suspended prison sentence. So there was the possibility of imprisonment. And the Supreme Court said when there's the possibility of imprisonment, counsel has to be provided.
I don't think that this will have a major impact across the country because most states already provide counsel, but this makes it a much clearer line.
Tell us, Lori, about the case of Carey versus Saffold. This involves the grace period for filing federal habeas petitions by state defendants, and more specifically, when that period is tolled. This is a complicated case because of California's habeas law. Tell us what this is all about and what the court decided and what impact it's going to have, because there's disagreement about that.
Well, ordinarily, state prisoners have to file their federal habeas claim within a year, but there's a tolling provision while there's pending state collateral review. In California, there's this unusual system where the defendant will file an initial habeas in the trial court. When he loses, he can either appeal within 10 days or he can file an original habeas again in the higher court. In this situation, that's what he did, and he has a reasonable period of time to do that, and he took about 4.5 months. If he was stuck with that initial 10-day period, he would have been out of luck. But what the court said, we will include within the tolling provision that additional reasonable period. The real issue is whether that will impact other jurisdictions that don't have the set deadline and really lengthen the process for the AEDPA habeas review.
And there was a lot of disagreement between the majority and the minority on what effect it would have beyond California.
That's right.
So we'll wait and see. Thanks. Finally, Irwin, Lee versus Kemna. This is the case of Ramon Lee, who was on trial for murder in Kansas City. He claimed when the murder occurred he was in California, and members of his family came to Kansas City to testify on his behalf, but they couldn't be found when their testimony was needed. So the lawyer asked for a continuance, and the trial judge denied it, citing his trial calendar and some personal commitments. The Missouri state courts affirmed the denial of the continuance, but they cited Missouri court rules requiring that the request be in writing and supported by an affidavit. Lee lost his habeas petitions in federal district and appellate court. What did the Supreme Court say?
The issue in the case is whether his failure to comply with the Missouri procedure in asking for continuance was an independent and adequate state ground that precluded habeas corpus. The Supreme Court said it wasn't, and habeas review was permissible. The Supreme Court pointed out that it wasn't a situation where Missouri consistently followed the rule. Also, the state trial court had not pointed to the failure to comply with the procedural rule as a basis for denying the motion. And also, Justice Ginsburg's majority opinion said the underlying purpose of the rule, giving adequate notice to the court of the desire for continuance, was met in this case.
And I think what's interesting here is that you have federal courts deciding whether there really is independent, adequate state grounds.
Lori, let me ask you this. Could you sum up briefly, anyway, how you see this term as a habeas term?
Well, at least with regard to the AEDPA, I think that the court has softened its impact by allowing the longer tolling period.
I think the other theme in these cases is the court is insisting that Strickland versus Washington be met, and it is a standard that gives great deference to trial court. It's a hard standard for defendants to meet.
Okay, thanks, Irwin. And thank you, Lori. This concludes our review of the Supreme Court's 2001 October term. As always, thanks to the Center's Board and Judicial Education Advisory Committees for help with case selection and analysis, to Center Director Fern Smith for her advice on all phases of the program, and thanks to our faculty who not only commented on the cases, but helped us design the program. I ask you again to complete and send us the evaluation form in your materials. We'll use your advice in planning next year's review. Finally, a note about Justice Byron White, who died April 15th at the age of 84. Justice White's passing means there are no living retired justices, a byproduct in part of the fact that there have been no appointments to the court for 8 years, a span not seen since the 1820s. Justice White's biography before his appointment is well known. A collegiate and professional football star, Rhodes Scholar, clerk for Chief Justice Vinson in 1947, prominent Denver attorney, and early supporter of John Kennedy, whom he knew from the Pacific Theater in World War II and who nominated him for the Supreme Court in 1962 when he was serving as Deputy Attorney General. Justice White put a premium on both personal modesty and judicial modesty. His opinions during his 31-year tenure were sparse and to the point, consistent with his response to a question at his confirmation hearing about his view of the role of the Supreme Court. To decide cases, he responded. Thank you for joining us.